I certainly want to thank everyone for showing up. It's actually very encouraging to see how many people are taking an interest in the water situation on the peninsula. Obviously, this evening's town hall meeting is the theme is Why Buy Cal-Am, and it's being presented by Public Water Now, and I'm Ron Cohen, the managing director. All right, who is Public Water Now? We're a community-based organization. We're concerned about the future cost of water, just to put it as simply as possible. In fact, we understand there's going to be a rate increase in July, is that right? Something for everyone to put in their Christmas stocking. We are actually consist of a wide variety of political diversity, and we've worked out a mission statement. We've tried to keep it simple, and that mission statement you can see listed up there, which is public ownership of Cal-Am's local assets by the Monterey Peninsula Water Management District. And our plans are to place an initiative on the ballot in June of 2014 to accomplish that goal. Now, I do want to mention one ground rule this evening. As you notice, our mission is very simple. It's very straightforward. In fact, everybody has agreed to check all other issues at the door. So when somebody wants to bring up groundwater replenishment and another person yells out, "You mean toilet water recycling?" we ask them to just hold that thought, because that's not the issue at hand. The issue at hand is whether we want to determine our future on the peninsula in terms of water, or whether we want to continue under the current regime as well as the California Public Utilities Commission. So we're going to ask you to do the same thing. If you've come here and you want to say talk about this desal versus that desal, or whether we should or shouldn't have groundwater recharge, I'm probably going to cut you off, because we really want to focus on the one issue. We find that if we keep it that way, we keep focused. So we talked about starting off with the why now, because the first thing when we announced our intentions that came out of the delightful editor from the Carmel Pinecone was a long diatribe on how this couldn't be the worst time in the world, and so forth and so on. A lot of us in the group feel like that a lot of decisions have been forced on us, and we think that's the reason why now is the right time. As an example, we're going to talk about a couple of the more egregious type examples. The Utilities Commission has given Cal-Am full profit on the dam, and we feel that that has turned a liability into an asset, despite the fact that the dam was not maintained over the years and pretty much left to go into disrepair. We also feel that Cal-Am has been adamant about not allowing any public ownership in this process. Now, originally with Marina, they started out with a public ownership strategy, but as soon as that began to have difficulties, a lot of us feel they took the opportunity and said, no more, nobody can join in, we simply want to be in charge of this thing, we're going to tell everyone exactly how things should go. We also found it kind of disturbing at one of the mayor's meetings that they had asked Cal-Am to come up with some legitimate alternate intake options for the desal plant, and they were pretty much rebuked and told, this is our option, the other ones are listed on a piece of paper, and if this one doesn't work, we're going to go to Plan B. Of course, we're going to look at the list and decide what Plan B is, but we will be 100% focused on one option and one option only. And of course, that worried the mayors, it worried a lot of people, that it was just another series of let's wait, let's delay, let's see. I mean, they've already admitted they're not going to have the desal plant ready by the end of 2017. And we're all taking bets on whether 2020 is going to be reached. The other thing is, We feel like they're proposing pretty much the same thing that they did in their last attempt, which wound up in failure. I'm especially referring to the issue of slant wells, taking head-on the whole issue of water rights in the Salinas Valley area. So that's one of the reasons why we asked our next speaker, Mark Del Piero, to come and join us. He is extensively involved on the peninsula for a number of years, and he has a great deal of experience in water issues and so forth. Mark?
This is a great crowd. Normally, issues like this draw very few people, and the fact that there are this many people in this room tonight is demonstrative of one thing to me, and that's that everybody's sick to death of their water bill. Yeah. I'm here tonight because the folks who are putting this on were kind enough to ask me to come and tell you some facts about the availability of groundwater from the Salinas Valley. The availability of groundwater from the Salinas Valley is about as available as groundwater from the Carmel Valley. And why is that? Well, for those of you that are not familiar with the Salinas Valley, let me just share some facts. 1946, the Army Corps of Engineers determined that the Salinas Valley groundwater basin was in overdraft. What's that mean? That means that collectively the property owners throughout the Salinas Valley were pulling more water out of the ground than was being recharged by natural rainfall. Why is that significant? Because it hasn't changed. And under California law, there was a case handed down at the very beginning of the last century, not the 21st century, 20th century, between the cities of Pasadena and Alhambra over groundwater rights. And it said that when you have an overdrafted basin, appropriators, like the California American Water Company, are not entitled to take any water. Let me just say that the last time the California American Water Company, collectively with the Marina Coast Water District and the County of Monterey, got together and conspired to take water out of the Salinas Valley, collectively that project was proposed. It triggered a lawsuit by the Ag Land Trust of Monterey County because the Ag Land Trust happened to own over 160 acres immediately next door to where the wells were supposed to be. And after not too long of a trial, Judge Lydia Villarreal ruled in favor of the Ag Land Trust on every count. The Marina County Water District, which was one of the partners, which was named defendant in the suit, lost. And why is that significant? Because the cost of that is being paid by ratepayers. Every time an appropriator, like the California American Water Company, tries to advance a project that is predicated upon stealing groundwater out of the Salinas Valley that belongs to somebody else, the resulting litigation results in damages awards that collectively the ratepayers of the California American Water Company end up paying. Make you feel warm and fuzzy? If you want examples of that, let's talk about it. After the regional desal project fell apart as a result of Judge Villarreal's decision, Cal-Am pulled the plug and walked away from the agreements. They were exposed to potential litigations with the County of Monterey and Marina Coast Water District. There's not been yet a resolution of the dispute between Marina Coast and Cal-Am, at least none that have been made public. However, there was a resolution between the County of Monterey and Cal-Am. Cal-Am promised to pay all of the costs that the county was exposed to in exchange for the county not enforcing the ordinance that I had a hand in putting together back in 1989 that requires desalination plants to be publicly owned. That ordinance, ladies and gentlemen, is still in full force and effect. It's the law of the County of Monterey. Because Cal-Am was able to pay the bills that had been generated by this just irrational collective conspiracy, if you will, to take water out of the Salinas Valley after 50 years of overdraft, because they were able to pay the county's bills, the county is now effectively barred by that settlement agreement from enforcing its own ordinance. It's important for everyone on the Monterey Peninsula to understand that this is not a new issue. The California American Water Company got sued in the 80s, long time ago, over their illegal pumping of the Carmel River. Why did they get sued? They got sued because they were taking so much water out of the Carmel Valley that it was causing vegetation along the Carmel River to die. It destabilized the banks, and as a result of the destabilization of the banks, when they had a flood, a bunch of houses ended up going down the river. And that is not conjecture, that is proof that was presented in front of the Superior Court and subsequently accepted by the State Water Resources Control Board. As fact, that was part of the determination that the State Board reached based on the factual evidence that was presented and that was not refuted by Cal-Am, that resulted in Cal-Am's problem that they have now faced since 1995. It was determined at that point in time, after innumerable evidentiary hearings, Cal-Am was illegally taking water out of the Carmel Valley. That was a long time ago, 1994, and they haven't come up with a solution yet. How many times has your water bill been raised during that period of time only to have the next headline on the front page of the Monterey Herald that their most recent effort has once again been a failure? The vast majority of people in the state of California are served by publicly owned water systems run by elected officials who actually serve their constituents, and they do it without making a profit. The presentations that you're going to hear tonight, ladies and gentlemen, offer you something you seriously need to consider, because candidly, I'm really tired of getting beat about the head and shoulders from an organization that I don't have much respect for.